So Michael Popok, Legal AF, you've heard about the Louisiana law forcing the 10 Commandments to be installed and taught in public schools, but where did that come from? Where did the attempt to establish a theocracy in America come from? It came on the back of two United States Supreme Court decisions from June 2022 that were issued about 6 days apart. We reported on those decisions on Legal AF at the time, but now we see the ramifications. That was an invitation by the right-wing MAGA, led by Gorsuch and Alito and Thomas and Amy Coney Barrett and the rest. It was an invitation to completely ignore and destroy the Establishment Clause of the First Amendment, James Madison's ideal that there not be religion in the public life in America, especially in education. That went out the window in 2022 with the destruction of a major super precedent that was taken off the books by Gorsuch and the right-wing MAGA, and now it's a free-for-all. And we have the attempts by states like Louisiana to reestablish and establish this country as a Christian country, whether you like it or not. That's what we're seeing with the United States Supreme Court with the 6-3 majority. The only reason they're ripping these super precedents off the books and pointing instead to history and tradition. Let's go back to old-timey times. Let's go back to the 1800s. Let's go back to the 1700s. Let's ignore the fact that during the 1800s and 1700s, women were second-class citizens, as they have rapidly become under the Trump administration and this court again. That slaves were slaves and not even black citizens. That women were treated as chattel. They didn't have the right to vote, nor did black Americans, who were barely Americans. But forget all that. What is this country's history and tradition as it relates to fill in the blank? And when you hear the Supreme Court majority, supermajority like Gorsuch and Alito and Thomas start talking about history, run for the hills. That is their tell. They're telling you that they're about to rip down 40, 50, 60 years of constitutional protections around your and my civil rights. And they're going to, now that they have the numbers and for no other reason, they're going to shove Christianity down our throats. Not just religion in the public place, Christianity down our throats, and states are listening. Especially, I'm surprised it's taken states like Louisiana this long. Now, the two cases that we talked about at length at the time, but it's important now, that are the foundation for everything we're about to see. And again, James Madison, who's the primary framer of the First Amendment, including its Establishment Clause, is spinning like a rotisserie in his grave. I assure you. He made it known in all of his writing, including the Federalist Papers, that there should be no religion suffused and infused within our civics, within our politics, within our federal government, right? You're free to worship as you choose, but the government should not be helping to establish a religion. The two cases I'm talking about, Carson versus Macon, a 6-3 decision, and then Kennedy versus Bremerton. In both, Justice Sotomayor wrote scathing dissents about the destruction of the wall between the church and state, not chipping away at the complete wholesale assault on and destruction of that by the right-wing majority. In fact, her opinion in Kennedy versus Bremerton, 35 pages, was longer than Gorsuch's majority decision. I'm going to read to you from it because she was so right on point. Here's what Judge Sotomayor warned us in the summer of 2022. She said the decision, and I'll just tell you what the decision was. Joe Kennedy, not related. Joe Kennedy was a football coach who for years forced his team, his football team, public high school football team, to pray. He would do prayer stretches. You know, they'd be stretching for their football game, and he'd be doing prayers. And then he got sideways with the school board because he kept going to the 50-yard line and doing what effectively was compelled mandatory prayer with his players in a public setting. And the school board said, enough is enough. You can go do your private exercise of your religion somewhere else. I mean, think of it this way. If somebody who's a Muslim who worshiped Islam, took their prayer rug in the middle of, football practice, but also forced the rest of the team to go buy, or he would hand out prayer rugs and do their prayers with him, there would be an outcry. And do you think this United States Supreme Court would be like, that's okay, that seems all right with us? Doesn't seem compelled. No, but because he's Christian and he's praying, and they basically threw away the entire factual record and ignored the entire factual record, which is totally bogus, totally made up. Joe Kennedy lied during his testimony, and that came out in the appellate record, but they ignored it because they wanted to make new law. And they wanted to throw away a test that had been on the books for over 40 years, which we used to refer to as the Lemon test, which is a test to make sure that government doesn't get too entangled with religion. It was as important of a test as in the Dobbs decision, in terms of precedent, throwing away 50 years of a constitutional right of a woman to choose by throwing away the Dobbs decision, like it was the morning trash. They did the same thing in the Lemon test, and they did the same analysis under history and tradition. Let's not use the Lemon test that served us well for 40 years, named after a case. Let's just use what we now, sitting here in 2022, 2023, we think history says about a certain thing, religion in life, religion in public life. And Justice Sotomayor had enough in her 35-page decision at the time. And she said, this decision about Joe Kennedy forcing people to kneel at the 50-yard line does a disservice to schools and the young citizens they serve, as well as to our nation's long-standing commitment to the separation of church and state. And then listen to this part. In doing so, the court set us further down a perilous path in forcing states to entangle themselves with religion, with all of our rights hanging in the balance. Well, states like Louisiana, and they won't be the last, have decided to take and stand on the precedent of Kennedy versus Bremerton and Carson versus Macon, I'll talk about that in a minute, and force religion down the throats and purposefully, actively entangle themselves in religion using public dollars. There's no other way to put it. If that's not a violation of the Establishment Clause of the First Amendment, I don't know what is. Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's TRYFUM.com and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today. In fact, I side, of course, with Sotomayor. There is no clearer violation of the Establishment Clause than that. The First Amendment's Establishment Clause prohibits the government from making any law respecting an establishment of religion. Right? It prohibits government actions that unduly favor one religion over another. And the government can't establish an official religion. Well, what are they doing here? Listen, I'm a Ten Commandment guy. I'm a Judeo-Christian person. You know, I have a Bible. It stops after the first part, but the first chapters. But I have a Bible. But it's not about me. and my personal beliefs and my ability to worship as I please in this country. But I shouldn't, if I don't practice that religion or I practice no religion, I shouldn't walk into a school and see the 10 Commandments. We already had Supreme Court precedent about the 10 Commandments being established in a public square, right? And the use of it. It's okay to me. It's not okay to somebody who's Muslim, who's Hindu, who's Baha'i, fill in the blank, or no religion at all, or agnostic, or atheist. And they shouldn't have that, or their children shouldn't have that shoved down their throat, pardon me, by the United States government or any state. In the Carson versus Macon case, which was also a 6-3 decision, these were like a week apart. You know, they gang up on us as a Supreme Court. They shoved down our throat in 2 big helpings, these cases destroying the wall between church and state. And we said at the time, we had a more elaborate legal analysis than that, but it was Carson versus Macon was a case in which Maine was using public dollars, or people were, religious families were trying to force Maine to use public dollars to supply and provide religious instruction in rural areas where there was no public high school. So where there was no public high school, they had to get on a bus and go somewhere, or they had to do home instruction. And there was, a parochial school nearby, a Christian school, Catholic school, fill in the blank school nearby. They wanted the state to pay for that. Well, that's our education of choice. Well, if it's your education of choice, you should, go do home instruction or go figure out a way to pay for it. The state shouldn't pay for your religious exercise, but not to that 6-3 majority of the United States Supreme Court. And they basically said, bye-bye, James Madison, bye-bye Establishment Clause and founding of religion, and forcing religion into the public square and into education in particular, because we're going to force Maine to pay for Christian studies in rural areas. And we thought that was breathtaking. And then the sucker punch to the solar plexus came in with the Kennedy versus Bremerton decision 6 or 7 days later. And then we saw the new changed landscape, and all the Christian nationalists in this country, who I am not against, not against anybody's particular religion. You want to live your gospel, whatever it is, more power to you. Just don't do it in a way that makes me feel bad about me, my personal choices about religion one way or the other, or my children. And that's where we're at. So I wanted to kind of do like a little x-ray exam of like, how did we get here with Louisiana and other states that are going to be coming, with the long line of precedent about the 10 Commandment, by the way, about the 10 Commandments, which prior Supreme Court precedent would have barred from being installed in public schools, but not under this right-wing majority. And every time, again, I'm going to leave you with this. I'm going to give you a special decoder ring. Every time the United States Supreme Court says history and tradition, we need to look to history, tradition. We're not going to establish a judge-made test, which is what we're paid to do as judges. We're going to look to history. We're going to become historians. We're going to be Mr. Peabody in the Wayback Machine and go back to our version of history, our distorted version of history, without any context, completely unmoored, untethered, without recognition of other people in that society that were second, third, and fourth class citizens, including half the society in the form of women. We'll ignore all that. How did they treat religion? What would they have done with the 10 Commandments? Who cares? What do I care what some old-timey guy, it would be a guy, old-timey white guy in 1800s would think about the 10 Commandments or about gun control? I'm sure he couldn't fathom, driverless cars running around China and people being able to have military-grade weapons in their backyard. I thought when I was in law school, and one of the reasons I went into this profession, is that the Constitution, as I was taught, was a living, breathing document whose precepts and principles guide us but evolve with time based on the mores of our particular culture. I thought that was the document, not this brittle, rigid owner's manual. It's not an owner's manual. That's the problem with the United States Supreme Court. The United States Constitution is not an owner's manual, right? It's not like, here we go, carburetor gets connected, and then what do we do? You can't run a car from it. It's precepts, its principles, its guiding principles. There's some requirements and restrictions, and there's the way that the federal government is arranged, and its relationship with the people, and its relationship with the states. Yeah, sure, that's all there, but it's supposed to be interpreted appropriately through the United States Supreme Court. I mean, the United States Supreme Court didn't even have those interpretive powers under the very Constitution that it's interpreting. Let me repeat that. The United States Constitution does not have, by way of the Constitution itself, the powers to interpret the Constitution. It came from a series of interpretations of the Constitution by judges like Chief Justice Marshall in 1807 and Marbury versus Madison. If we didn't have a case called Marbury versus Madison, there would be no modern Supreme Court. Isn't that ironic? The interpretation of the then relatively young 20-year-old document laid the foundation for a Supreme Court to make its decisions because it's not in the literal text of the Constitution. That should be a head exploder for those that are originalists and textualists, because their own position, their own function is not in the literal text of the Constitution. Try that on for size. We'll continue to follow everything related to the United States Constitution and this United States Supreme Court right here on the MeidasTouch Network and on Legal AF. Join me on Wednesdays and Saturdays at 8 p.m. Eastern Time at the intersection of law and politics, where we bring it to you uncensored, unfiltered, unhinged, unplugged, all the uns. Wednesdays, I do it with Karen Friedman, Nick Nifolo. Saturdays with Ben Mycelis, and then on hot takes like this about every hour on the MeidasTouch Network. And then you can follow me, Michael Popok. Go over to playlists and contributors under the MeidasTouch YouTube channel, where you can free subscribe and find me, Michael Popok, there. 1,200 hot takes, just like this one, at that intersection of law and politics. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.